Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, March 29th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to monitor that and periodically answer any questions as they come up. And in these weekly live streams, we try to keep up to date with the latest Supreme Court news. So we'll just be touching on some of the developments at the court over the past week. And here's what I plan to cover today. This week was relatively quiet compared to last week. The court didn't grant any new cases this week, and there was only a single opinion in an argued case. It's a case called Hall v. Hall, which is a case about the right to appeal when multiple cases have been consolidated together. And I'll discuss that opinion later on in the live stream. But there are still a bunch of other interesting developments to talk about. So I'm going to begin by running through some of the orders and other news from the court. And let's start with this week's death penalty stay applications. So there was one execution scheduled for this week on Tuesday, March 27th. It was a man by the name of Rosendo Rodriguez, who was convicted in Texas and sentenced to death for a 2005 rape and murder. He was referred to in the news as the suitcase killer because his victim's body was found stuffed in a suitcase in a landfill. And he was later also connected to an earlier murder where another victim's body was found in another suitcase in the same landfill. He filed a stay application with the Supreme Court on Monday. So this is an application asking the court to stay his execution. And his application and his petition to the court was arguing an actual innocence claim. So he was arguing that he was actually innocent of the crime he'd been convicted of. And the kind of specific hook that he was asking the court to grab onto in staying this case was about allegedly fraudulent practices by the medical examiner who performed the victim autopsy in this case. It was kind of an odd petition and stay application because it never really connected the alleged problems with the medical examiner to Rodriguez's actual case or explain how those problems undercut the evidence against him. And obviously the state of Texas opposed the application for a stay, and the court denied that stay application on Tuesday with no noted dissents, and he was executed on Tuesday evening by lethal injection. So that's that was the only execution on the calendar this week. There is one other update about the case of Doyle Ham, and this is one that we talked about a few weeks ago. Now, he was a man who had been convicted and sentenced to death for a 1987 murder robbery in Alabama, and he had been scheduled for execution on February 22nd. But he had made an application to the court, stay application, arguing that it would be cruel and unusual punishment to execute him by lethal injection because of his collapsed veins that he had due to some medical issues that would cause it to be cruel and unusual punishment. And the Supreme Court denied that application, and the execution went ahead as scheduled. However, the execution ended up being called off late into the night. This is on February 22nd, after several hours of the execution staff attempting unsuccessfully to find a usable vein for the lethal injection. So this execution, which was described as a botched execution, was later widely described as a torture involving repeated punctures of his legs and groin as they attempted to find a usable vein, and it resulted in significant bleeding and allegedly may have punctured both his bladder and an artery in his leg. And the question after this was, in light of how this execution actually played out, and the execution team's inability to actually successfully in a several-hour period successfully find a vein they could use for the injection. Would Alabama try again? Would they reschedule his execution and try and do it on another day? The answer came this week on Monday. Ham's attorneys apparently reached a settlement with the state of Alabama, and as part of that undisclosed settlement, Alabama has agreed not to schedule another execution date. So that it's kind of a gruesome chain of events, but resulted in Doyle Ham getting a reprieve and being spared the death sentence by the state of Alabama. That's it for death penalty news this week. I mentioned a few minutes ago that the court did not grant any new cases this week. That leaves the court at only 7 cases granted so far for next term, the term beginning in October. And I've mentioned this on previous episodes, but basically, by the time the court leaves for its summer recess at the end of June, the court needs to have filled up its fall calendar. By the time the court returns at the very end of September, there just isn't enough time to fit new cases. If they grant new cases at the very end of September when they come back, there isn't really enough time to get those cases briefed and on the calendar until basically January, and even that is a relatively short time frame, but that's doable for those early grants. And so generally, the cases that are on the docket that have already been granted when the court leaves for its summer recess are the ones that are going to fill up the months in the fall, October, November, and December calendars. The court likes to have a full calendar, as in recent years it hasn't really filled up its calendar like this, but say a decade ago, the court typically liked to try and have two arguments each day on its argument calendar. And there are 17 days on the argument calendar between those 3 months. Typically, it's 6 days a month, but there's holidays that throw that off. So there's 17 days over those 3 months. So that would mean they need 34 cases to fully fill up those 3 months of argument. And as I said, they've only got 7 right now. I looked back over the statistics for the past decade or so, and over about the past decade, the court has averaged about 25 cases granted from the beginning of April through the end of June. If the court hit that average this year, that would still place it a little bit underneath the target for filling up the fall calendar, but pretty close. But that number is just an average, and there really is significant variation from year to year. And for example, last year, only 16 cases were granted from the end or from the beginning of April through the end of June. At that pace, they would have a very light fall calendar. So it remains to be seen how many cases the court adds. And this is just in recent years, there's been a long-term trend going from the 1980s when the court used to hear 150 or more cases a year to the early 2000s when the court was down to somewhere in the 80s to recent years where it's been below 70 many years. The court's docket has just continued to dwindle, and this year is a record low number of cases are going to be decided. It looks like at the end of the term, it looks like we're only going to have a total of at most about 63 opinions and argued cases, and it could be less depending on there's. I'll talk a little bit later. There's possibilities of a few cases that, or at least one case that could disappear from the docket. So it's an interesting question whether this is just the new normal, having these very light terms with only 60 some cases on the docket. But we'll see as we get later into the spring how many cases the court adds before they go on their summer recess. This coming Monday, the 2nd, is the next possible date when the court might announce some grants. They had a conference earlier today, and those would be announced on Monday, typically. But then there won't be another day where they would be adding new cases until April 16th, when the court begins its April oral argument session. So we'll just have to keep watching and see how next term shapes up as more cases get added to the calendar. So I'm going to move on to some other developments over the past week. There are two cases where there were some interesting developments related to recusals. Um, now, justices occasion it's not that unusual for one or another justice to be recused from hearing a particular case for a variety of reasons. Sometimes this is because a judge had participated in the case as a lower court judge or as a government official in some capacity before they join the court. Sometimes it's because a judge has some personal connection to a party or to an attorney in the case. Or, for example, Justice Breyer uh, recuses himself whenever a case comes up to the court that was decided by his brother Charles Breyer, who's a district court judge in California. And so when his brother was the judge below, Justice Breyer typically recuses. That's just an example of that. And then also when there's a financial stake by a justice in the case, for example, if they own stock in a publicly traded company that is a party to the case. But there were two cases this week where there were some just more unusual developments related to recusals. The first is a case called Washington v. United States. And this is a case about the fishing rights of various Pacific Northwest Indian tribes under some treaties dating back to the 1850s. Now, what happened is on Friday, the clerk of the court sent a letter to the parties in the case indicating that Justice Kennedy was now going to be recused from the case. And I'll read the language from that letter. It says, "I'm writing to inform the parties that Justice Kennedy learned recently that while serving as a judge on the Ninth Circuit Court of Appeals, he participated in an earlier phase of this case." And then it gives a citation for a case, and the citation is a decision dating from 1985, Ninth Circuit Court of Appeals case from 1985. Now, Kennedy has been on the case on the Supreme Court for 30 years, and this is a case from 33 years ago. First of all, it's just amazing sometimes to see that this is a legal dispute that has been ongoing for more than 33 years. If you think about it, that means this case is likely older than most of the clerks working for the justices on the court. And it's just kind of an odd little thing. It's not really surprising that something like this was missed. When you look at Justice Kennedy, who's been on the court for 30 years, he's probably heard more than at least 2,500 or more cases in his 30 years on the court. Not to mention the huge number of cases he heard on his years on the Ninth Circuit Court of Appeals before he joined the court. It's not at all surprising that he wouldn't have immediately recognized or remembered this one particular case from 33 years ago. This has kind of renewed some calls by watchdogs of the court for more transparency and more modern conflicts checking methods by the court to try and catch these things, because there have been some more embarrassing slip-ups in recent years of justices not realizing that they should be recused from cases. This one again seems like a very hard one to catch given just the age of the case, but that is an issue that people have paid some attention to, because there have been some higher profile errors in recent years where justices did not recuse themselves as soon as they should have. The second case is another unusual circumstance because it's the rare case of an unrecusal. So this is a case called Western Gecko v. Ion Geophysical Corp. And it's a case about the scope of damages available in certain international patent cases, and that's scheduled to be argued in the April argument session. I don't think I mentioned it, but that Washington v. United States case, where Justice Kennedy is now recused, that's also in the April arguments. Now, Justice Alito had been recused from hearing this case, so this was a case that was only going to be heard by 8 justices, and the court, when a justice is recused from hearing a case, normally there's no explanation of why a justice is recused. There's just an indication that a particular justice did not participate in the proceedings relating to the case, but it doesn't explain. Normally, it doesn't explain why. That letter from Justice Kennedy was the exception, just because it's explaining this late recusal. Normally, the justices don't explain why, and sometimes it can be a little bit of a mystery, and it's not immediately obvious why a justice has recused. But here, the reason was pretty apparent. So Justice Alito is one of only 3 justices on the court who continue to hold shares in individual stocks. The other 2 are Justice Breyer and Chief Justice Roberts. And the stockholding, it occasionally requires the recusal when a company is party to the case. Now, most justices, they only hold like mutual funds or index funds, or they place any stocks that they own in a blind trust, so that they're not aware of their holdings and can don't have to worry about that for hearing cases. But those 3 justices do own shares in individual stocks, and that does occasionally require one or the other of them to recuse in a particular case. And here, Justice Alito owns some stock in a company called Schlumberger, which is a French company that owns Western Gecko, one of the parties to the case. So it was pretty clear that was his reason for recusing from the case. Yesterday, the court's press office indicated that Justice Alito is no longer recused from the case. No explanation was given, but the obvious explanation is that Justice Alito has since sold off his Schlumberger stock, presumably just so that he would no longer have to be recused and could hear this case. And in recent years, all 3, the Roberts, Alito, and Breyer, have been gradually divesting from their individual stock holdings. So this is kind of just part of that trend. It's just a little unusual because it's happening while the case is after he had already initially recused, and while the case is already pending before the court. So moving on to some other pieces of news. This is kind of another update from something I mentioned last week. In last week's live stream, I mentioned that a piece of legislation known as the Cloud Act had been included as part of the proposed that massive omnibus spending bill. And as expected, the omnibus bill was signed into law on Friday, March 23rd, making the Cloud Act now the governing law. Now, the Cloud Act, CLOUD is an acronym standing for Clarifying Lawful Overseas Use of Data. And this is an act that it explicitly authorizes law enforcement to obtain electronic data that's held outside of the United States. So if a company, for example, an internet service provider or a technology company of some sort, holds customer data in a server that's located outside of the United States, there was a dispute over whether, under the governing law, which is called the Stored Communications Act, whether the United States was able to use that Stored Communications Act to obtain that data stored outside of the United States. That is the issue that's before the court in the case United States v. Microsoft that was argued in February this term. So that's the issue that's currently before the court. But now that the Cloud Act has passed, which amends the Stored Communications Act and explicitly allows this type of obtaining this type of data, although it also provides certain procedures to allow companies to challenge this kind of collection. It raises the question of what's going to happen to the Microsoft case. After that law passed on Friday, the Solicitor General filed a letter with the court informing the court of this new legislation. And I'll read just a relevant couple sentences from that letter. It says, "The United States is currently determining whether, and if so, to what extent the passage of the Cloud Act affects the court's disposition of this case. It intends to file a supplemental filing addressing the question as promptly as possible." So that filing remains to be seen what that filing will say, but most commentators seem to be predicting that this case will end up being remanded to lower courts for further proceedings in light of this change of the governing law. It seems extremely unlikely that the court will do anything with this case until it hears more from the parties on this issue. They don't want to waste any time on working on an opinion that's going to be on a non-issue because the law has changed between when they issue it and when it comes out. And as of earlier today, at least, there was nothing on the docket from Microsoft. They had not weighed in, at least publicly, with the court, though. It's likely that Microsoft's attorneys are in communication behind the scenes with the Solicitor General over how this affects the case. But there's a very good chance that that case is going to disappear from the court without an opinion this term because of that change in the law. But again, we'll just have to wait and see on that. So earlier this week, Monday through Wednesday this week, the court heard oral arguments in 5 cases. In last week's live stream, I previewed those 5 cases. And today, I just want to comment briefly on one of those cases. On Wednesday, the court heard argument in Benesek v. Limon. Now, this was a constitutional challenge to partisan gerrymandering in Maryland. And I discussed this a little bit last week, but the court had already heard one partisan gerrymandering case earlier this term. It was a case called Gill v. Whitford, which is a case out of Wisconsin that the court heard the first week in October. That's the very first week of this court term. So that case was heard right at the beginning of October. And then in December, this Maryland case, Benesek v. Limon, the court placed it on its argument docket. It indicated that it was going to hear this case as well. And there was a lot of speculation about why the court had granted a second gerrymandering case. Often when the court has multiple cases on a closely related legal issue and it has granted one, when other cases come up with that same issue, the court will just hold those cases. That's just kind of basically do nothing on those cases, let them just kind of sit there and wait until the case that was granted has been decided. And then in light of that decision, often those other cases just get sent back down to the lower courts to just determine the effect of the court's decision on those other cases with related issues. But here, rather than holding this Maryland case, the court added it to its docket, and people wondered why. And there were different theories. One is that the 2 cases, although they concern the same issue, they concern a political party gerrymandering, that is, drawing electoral districts with the explicit intent of favoring one political party over the other. The legal theories that were used to challenge that gerrymandering were quite different in the 2 cases. The Maryland case, the one that was just argued this week, was a First Amendment case, so arguing that this was retaliation against people on the basis of protected First Amendment activity, that is either partisan affiliation or a past voting behavior or things like that. And while the Wisconsin case was a equal protection case, so it was kind of different framings of the legal argument. And it could be that some of the justices thought that there was more merit to the First Amendment argument, that was a better way to decide these cases, and so they wanted to bring a case with that framing of the issue rather than the equal protection framing from Wisconsin. Another explanation some were giving was that it was kind of for partisan cover for the court. The Wisconsin case was a case that had the Republicans kind of as the role of the villain in the case, the party that had gerrymandered the districts to give themselves a strong advantage in winning electoral districts. And the Maryland case was the reverse, where it was the Democrats in charge of Maryland who had gerrymandered that state to give themselves a sizable advantage in the electoral districts. And so maybe there was a thought by some that this would kind of, if they decided both cases and overturned both gerrymanders, it would give the court a more of a just more of a look of neutrality, in that this is not just goring the ox of one side over the other. But again, that's all speculation. But there was some interesting comments by Justice Breyer during the oral argument yesterday that seemed to maybe shed some light on what's going on inside the court. So again, the Gill v. Whitford, Wisconsin case was argued way back in October. No decision has come out yet. It wasn't expected. Once the court granted the Maryland case, it was expected by most people that there was no way that the Wisconsin opinion would come out before that case was argued. But it was anyone's guess what was actually going on inside the court as far as deciding that case. Justice Breyer, at one point during the argument, referred to three political gerrymandering cases: the Gill v. Whitford, Wisconsin case, this Benesek v. Lamone, Maryland case, and he also referred to a third case out of North Carolina. It was a case called Rucho v. Common Cause, which the court has just been holding pending its decision on the Wisconsin and Maryland cases. But he referred to those three cases, and let me just read from the transcript. This is him questioning one of the attorneys in the case, and he says, "What would you think of taking the three cases and setting them for re-argument on the question of standing, and there we'd have all three variations in front of us, and we would enable people who have an interest in the subject generally to file briefs, and we'd see them all together, and they could attack each other's standards, or they could support each other's standards, or they could attack any standard. But there we'd have right in front of us the possibilities as thought through by lawyers and others who have an interest in this subject." And then he expanded a little more later. He said, "You could have a blackboard and have everyone's theory on it. And then you'd have the pros and cons, and then you'd be able to look at them all, and then you'd be able to see perhaps different ones for different variations. And maybe there's different parts of gerrymandering that rises in different circumstances." So it was a suggestion by Justice Breyer that maybe these cases should be held over to the next term and re-argued. And so it's and he specifically asked the attorney whether the attorney saw any downside to holding these cases over until next term. Now, it's again, this is all speculation, just based on this comment by Justice Breyer. Although, if you read the media coverage, news coverage of the oral argument, that there's a very, very strong consensus that that commentators and court watchers were unable to really discern any strong indication of how the court intends to go on these cases. The justices really, many of the justices seemed very unsettled about how to what kind of rules should apply in this case, how this case should be decided. So it really does seem like there is still things that are up in the air in this case. But again, it's all speculation. But it's just interesting to think about what might be indicated by Justice Breyer's comments. Him asking the parties whether there's any downside to holding this over until next year, it seems to strongly suggest that whatever the court is inclined to decide on these cases, it's not going to order something that changes, not going to order something that disrupts the upcoming 2018 election. Otherwise, that would be an obvious downside to holding this case over till next year, that would put any decision until after the election. So the fact that Breyer is suggesting he doesn't see any downside to holding this over suggests that whatever the court does, it's not going to want to disrupt this upcoming election, which is getting very close now. And that is consistent with the court's practice in a lot of election cases of being very reticent to allow courts to make changes to election rules very close to an election or after election processes are well underway. And it suggests possibly that the court is either having a hard time assembling a majority in Gill v. Whitford, or at least a hard time in getting an opinion, a satisfactory opinion, getting to a rule that a majority of the court is happy with. Or perhaps it just suggests that Breyer feels himself to be on the losing side in Gill v. Whitford and is trying to buy more time for further consideration of the case. But again, it's all speculation. Some commentators have suggested that possibly the difficulties in working through Gill v. Whitford and coming to some sort of decision on it could be part of the cause of a general slowdown in the court's work, and an explanation for why the court has issued so few opinions so far this term. That this is a case that's eating up a lot of their available time. But again, this is all speculation. There's also the possibility that the court, if it really can't, is having trouble coming to any good decision that the justices are happy with in this case. It could be looking for ways to get rid of this case, and delaying the Maryland case till next term would be a good way of mooting the case and getting rid of it. This case came up to the Supreme Court on a preliminary injunction. If the election is already basically over, that would make it a non-issue, and at least for now, that case would go away. The Wisconsin case also has standing issues, whether the parties that are in that case challenging the Wisconsin gerrymandering are really the right people to be able to bring that challenge, and that's a way that the court could get rid of that case without really touching on the core gerrymandering issues. So, if the court really can't decide, it may be looking for a way to get rid of these cases. But again, we won't really know until something official comes out from the court, either opinions in these cases or some other action, rescheduling or delaying or getting rid of these cases. So we're just going to have to wait and see. So last piece of news before I move on to the new opinion for this week was a rare appearance by retired Justice John Paul Stevens. He was in the news this week after he published an op-ed in the New York Times on Tuesday, March 27th. And it was an op-ed arguing for the repeal of the Second Amendment. This is Justice Stevens. He left the court in 2010, but he remained fairly active shortly after leaving the court. He wrote and published 2 books after leaving the court. The first one, published in 2011 and called Five Chiefs, was a memoir about his legal career, going from the time he was a law clerk in the late 1940s all the way through his retirement in 2010. And then his book in 2014 was called Six Amendments: How and Why We Should Change the Constitution. But Stevens, who was already 90 years old when he left the court, is now 97, soon to be 98 years old. And his last public appearance was almost a year ago in May of 2017. So this is kind of one of the first, it wasn't an actual appearance, it was just a newspaper publication, but the first kind of news from Justice Stevens in quite some time now. Now, Stevens's position on the Second Amendment is not a new one for him. And I mentioned his book, his 2014 book called Six Amendments. One of those 6 proposed amendments in his book was an amendment essentially overturning the court's 2008 Heller decision. That was the decision that held that the Second Amendment protected an individual right to self-defense. And he had proposed in that book overturning that decision, and that piece was also at the time excerpted in a 2014 Washington Post opinion piece. So this is familiar ground for Justice Stevens in his post Supreme Court life and public writings. Despite all the recent attention to and calls for stricter gun control and things like that, his op-ed didn't necessarily go over that well among some people on the left side of the political spectrum, where you might have expected it to have the most purchase. Just as a few examples, there were articles by Harvard law professor Noah Feldman in Bloomberg News, by Matt Iglesias at Vox, by Harvard law professor Larry Tribe in the Washington Post, and articles by Charles Pierce in Esquire, Jay Willis in GQ, various publications, all by writers, all of whom are supporters of stricter gun control, who were quite critical of Stevens's piece and kind of variously characterizing his proposal as either unnecessary or counterproductive or even politically naive. So it didn't necessarily get the most friendly reception, but in any event, it's interesting to see Justice Stevens kind of making a increasingly rare for him appearance in ongoing public debate. So moving on from that to the opinions, there was, as I mentioned, only one opinion in an argued case this week that was issued on Tuesday this week. That brings our total for the term to 17 opinions of a total expected number of 63. And again, as I mentioned before, that could actually go down and be less than 63. So that means we're expecting 46 more opinions by the end of June. That's, assuming that the gerrymandering cases are decided, and assuming, and that's if the Microsoft case stays on the docket and gets decided, which seems unlikely at this point. So again, 46, maybe 45 cases left to be decided. That's slightly higher than the number of outstanding opinions over the last 3 years. I looked back over the last 3 years, and each year in this time period, they had somewhere from 40 to 43 cases left to decide. So it's only slightly higher this year. But that's despite this term's lower caseload, where the court has lower total cases, but still has more outstanding cases it hasn't decided yet. And to frame things in a different way, there's only 13 weeks remaining of the court's term. Um, and so just dividing evenly over that, that's an average of 3 to 4 opinions per week that the court would have to put out to uh, finish up its work by the end of June. And a few of those weeks, there's no scheduled sitting where the court would typically issue opinions. And as is always the case, that these numbers will likely be heavily backloaded. There'll be many more opinions issued in the month of June, especially the last three weeks or so of June. Will likely have a large share of the remaining opinions. But we should. That's why it was a little surprising, given the number of cases that are still out there, that we only got one single case this week, and we should be expecting from here on out in the rest of the term a pretty regular flow of opinions out of the court in order for them just to get through everything by the end of the term. But again, we'll see. So finally, the last thing I want to cover is just the one opinion this week. And this is a case called Hall v. Hall. And this was argued on January 16th. And I previewed this case on this podcast in the weekly live stream. And this is, this was episode 19 of the podcast, either on YouTube or the audio podcast, when I previewed this case. The opinion in this case is unanimous opinion by Chief Justice Roberts. And this is a case about appeals in a consolidated case. Now, in a minute, I'll break down what that means. But first, I'm just going to briefly give the facts of the case, just a kind of real quick discussion of the facts, just for a little background. So the underlying dispute here, it was a dispute between two siblings over the control of their late mother's estate. The details aren't too important, but there were two separate actions. One was by the siblings were named Elsa and Samuel Hall. So one of the suits was by Elsa as a trustee of her late mother's property, a trust containing her late mother's property, against her brother Samuel, alleging that he had misused his mother's property. And the other action was by Samuel against Elsa individually, alleging that she had exerted undue influence over her mother before her mother passed away. These cases were consolidated. I'm going to discuss that more in a moment. But they were consolidated and eventually tried together in a single trial. Elsa lost in both cases. And one of the two cases, however, there were more proceedings in the trial court. The trial verdict ended up getting vacated. There was a new trial. It was still ongoing. But the other of the two cases, the two original cases, after the jury verdict, Elsa immediately appealed that case up to the Court of Appeals. However, the Court of Appeals dismissed the appeal, saying that there was no final judgment that could be appealed. So I'm going to explain in a moment what all that means, the consolidation and final judgment. So first, consolidation. Consolidation is just a general term for combining multiple court cases together. This happens at the Supreme Court level. For example, the Supreme Court will sometimes consolidate cases for argument and usually for a decision and opinion. There's several cases this year on this term's calendar that are consolidated. Just for one example, there's the case Epic Systems v. Lewis, which was a case about employment arbitration agreements. And this is actually three separate cases that the Supreme Court consolidated together for argument. Each of those cases had different parties, but they all involved the same basic legal issues. So the court consolidated them together to have a single oral argument and to issue a single opinion that will decide that legal issue for all those cases. So that's just as an example of the Supreme Court. But in this particular case, we're talking about the district courts, the trial courts in the federal system. And in the district courts, under a rule, it's Rule 42A of the Federal Rules of Civil Procedure, it allows consolidation whenever there's a common question of law or fact between two cases. two or more cases. And that general rule, Rule 42, dates back to 1938 when the Federal Rules of Civil Procedure were first enacted. But the typical situation where this happens is when you have cases that involve either the same or overlapping parties and closely related factual circumstances, where a court will take those separate cases that have this kind of factual or party overlap and will consolidate them together so they can all be handled just in one single proceeding before a single judge. Sometimes this can be done for limited purposes. So, for example, for pretrial purposes, just for discovery, that's the exchange of various documents related to the court. For motions, when parties are trying to get a case dismissed or things like that. Or sometimes they're consolidated basically completely all the way through, including a trial. And that was the case here in this case. These two actions involving the Halls about the mother's estate were both consolidated and tried in a single trial. So what's the point of consolidation? The basic the purpose is for just efficiency, judicial efficiency. It allows a single judge to hear all the aspects of a case. The trial judge gets deeply involved in the factual record of the case, and if they're already reading all of the filings and documents and things related to one dispute between the parties. If there's other closely related disputes involving the same parties, it makes sense for that same judge to have all that before them. They can coordinate the discovery and various hearings. It makes it easier to coordinate the attorneys' schedules because oftentimes there's overlap in the attorneys between these cases as well. And another benefit, aside from just efficiency, is it avoids inconsistent rulings between two cases. So it avoids the situation where if you have two closely related cases with overlapping issues before two different judges, that judges might just decide things that are completely inconsistent between those two cases. And this avoids that and keeps it in one place. So here, both of these cases involved the exact same dispute over the same estate of the mother. There were overlapping parties. It wasn't exactly the same because the sibling Elsa was sued as an individual in one case, and she was suing as the trustee of the mother's trust in the other case. But it's overlapping enough that it made sense to put these together in a consolidate these before a single judge. Now, so that brings me to something called the final judgment rule. Now, the final judgment rule is a rule that a case can't be appealed until there's a final judgment, and a final judgment is when all claims of all parties to the case have been resolved. So a legal case, there may be numerous legal claims brought by parties, and there may be numerous parties involved in the case on either side as plaintiffs or defendants, making various claims against various other parties. And until all the claims of all the parties are resolved, there isn't a final judgment. So if, for example, one particular claim is dismissed or decided in some way, or all the claims of a particular party to the case are decided, the case is still normally unappealable until all the claims of all parties have been resolved. There are certain exceptions that aren't really relevant here, but there's also a procedure by which a district judge, that's the trial judge, can make exceptions to this by entering a final judgment on less than all claims of all parties by making an express finding that this is appropriate because there's no reason for delay and it would make sense to allow immediate appeals of the decision. So there is this exception, but by default, until there's a final judgment on all claims of all parties, no appeal is necessary. And there's some reasons for this. The purpose of this is just to prevent inefficiency of having these piecemeal appeals, of having different aspects of the same case going up and down to the appeals court and back down to the trial court. It can disrupt the trial court's process in trying to work through the remaining issues and claims in the case. It forces the appeals court to decide unnecessary issues that if it had let things go through, maybe if a particular claim, for example, gets dismissed, but that party could have won on a different claim that's still alive, then it may be completely unnecessary to decide an appeal on the claim that was dismissed, for example. And it repeatedly uses up the time of the appellate court, which needs to kind of get up to speed on the case, which it isn't intimately familiar with like the district court would be. So that's the general rule, final judgment rule. So the question in this case is, how do these two things fit together? Consolidation of cases and the final judgment rule. if two cases are consolidated, and here we're talking about consolidated for all purposes, including through trial. If they're consolidated and one of those two cases is completely resolved, can that be immediately appealed? Is that a final judgment in that consolidated case, or do we have to wait until all consolidated cases, all cases that are consolidated together, are final before you have a final judgment that's appealable? And this question, it seems like just a kind of a picky little technical question, but it can be crucially important. Has a great importance. The deadlines on filing appeals are very strict. If a party misses the deadline to appeal, then that right to appeal may be lost permanently. So you have a situation where if a party believes the judgment is final, but it's for example, a judgment on one of the two cases. So this is the situation for Elsa here, who believed that one of the two consolidated cases was final and wanted to appeal it. Then it results in these wasteful, premature appeals that end up just getting dismissed and wasting people's time. But the other side is the potentially worse one, and that's if the decision on one of these two cases actually is considered a final judgment, but a party believes that they have to wait for all of the consolidated cases to be finished before they can appeal, they may miss the deadline and miss their right to appeal, and that could be permanently lost. So it's important for parties and the courts to know what the rules here are, one way or the other. There was a precedent in this area, a case that's on a similar issue from 2015. It was a case called Gelbohm v. Bank of America Corp. And that was a case involved cases that were consolidated in what's known as an MDL, which stands for multi-district litigation. And multi-district litigation is just a kind of a special case of consolidation. That's where there are numerous cases involving the same sort of circumstance. A lot of times this may be class actions or other types of torts against a company that are brought in courts all over the country. So, for example, in various types of big litigation about things like asbestos, or litigation against cigarette companies, or litigation in various environmental or product liability claims, there may be numerous actions filed against the same defendant in various districts across the country. And when that happens, these may be consolidated into a single district for various pretrial purposes. And that's known as an MDL, for multi-district litigation. And this previous case held that in that situation, this MDL situation, when one case was part of this MDL, this multi-district litigation, was resolved. So, for example, the claims were dismissed on some grounds or something like that. That did count as a final judgment, and they did not have to wait for the entire MDL to complete. But here, the situation is a little different, because those MDL cases, as I mentioned, are only consolidated for pretrial purposes. So they're not these fully consolidated for all purposes, including trial, which is a little bit of a different situation. So the question here was, when you have cases that are fully consolidated, does that change things? Do they count as basically a single action? So the court basically decided no. In that case, even when cases are consolidated for all purposes, including trial, the cases retain their individual identity. They're still two distinct cases in certain respects, including becoming final for purposes of an appeal. And the court has various reasons for this. Basically, it mostly comes down to the meaning of the term consolidation. And the court says that basically consolidation, the word consolidation, is a legal term of art with a history in U.S. law that goes all the way back to a statute passed in 1813. And the court says that basically this term was consistently used from 1813 all the way through 1938, when the rule of civil procedure number 42, when that was enacted. That whole 125-year time frame, the consolidation was used to mean two cases had been joined together but not completely merged, and they did retain their separate identity for judgment and appeal. And so the court reviews kind of the pre-1938 practice. It recites a history of several past Supreme Court cases ranging from 1852 all the way up to 1933, that treated consolidated cases as retaining their distinct identities, and also noted this practice was confirmed by lower federal courts and also by legal treatises of the time period. And then the court goes on to discuss the drafting of Rule 42, the rule that was implemented in 1938, and notes that this rule was expressly modeled on the existing consolidation statute, so that it wouldn't be expected to have made a major change. The court, Chief Justice Roberts' opinion, it quotes, this is a quote that will be familiar to students of statutory interpretation. It's a quote from the Supreme Court Justice Felix Frankfurter from a law review article that he wrote back in the, I believe in the 1940s. And the quote from that article is, "If a word is obviously transplanted from another legal source, whether the common law or other legislation, it brings the old soil with it." And that's just to say the word consolidation had kind of a legal understanding, and the new rule was by adopting, carrying over that word, was carrying with it that understanding that existed under the previous law before that. There was one argument made that the court specifically addresses that was made by the other side that here, let me just read briefly some of the actual language of Rule 42. Rule 42A, it reads in part, it says, "If actions before the court involve a common question of law or fact, the court may, 1, join for hearing or trial any or all matters at issue in the actions, or 2, consolidate the actions." And there's more to it that's not relevant here. But the argument there is made that Section A1 allows joining actions for hearing or trial, and the argument there is that already covers this kind of partial, joining cases together incompletely. So A2, when it provides for consolidation of the actions, that must mean something broader than just joining them for hearing or trial. But the court responds very simply to that and just says, no, actually, A1 is much more limited. That's just talking about consolidation. That's talking about joining things just for hearing or trial. Consolidation is broader in the sense that it allows for all purposes, for discovery and other pretrial motions and hearings and things like that. So that the court explains there's no contradiction and there's nothing superfluous or redundant involved there. The court also says that it looks at the notes that accompanied the Federal Rules of Civil Procedure by the Federal Rules Advisory Committee, which was the committee that was in charge of drafting these notes, and it says basically when Congress enacted the Rules of Civil Procedure, this wasn't the kind of change they would change the meaning of a legal term without saying anything about it. And here's a quote from the opinion. It says, "No sensible draftsman, let alone a Federal Rules Advisory Committee, would take a term that had meant for more than a century that separate actions do not merge into one, and silently and abruptly reimagine the same term to mean that they do." So that's just just kind of an interesting restatement by Roberts of this idea that there would be some indication if they had intended the terms to change meaning. And the court also cites a leading legal treatise that was contemporaneous with the enactment of the 1938 rules that stated specifically that consolidation doesn't completely merge cases together. And then the court went on to cite several of its own post-1938 precedents of the court that treat consolidated cases as still retaining this distinct legal character. So, so after going through all that, the conclusion was, again, this was a unanimous decision by the court that just says that basically consolidation does not completely and totally merge these cases such that a final judgment would be needed for all cases that are consolidated together in order to appeal. One interesting thing to note here is there was one amicus brief filed in this case by several retired U.S. district judges, including some very well-respected district court judges. And they argued the other side of the case, the losing side here. They argued that judicial efficiency is much better served by treating these consolidated cases as a single case for purposes of the final judgment rule. And for many of the familiar reasons that I described above about why the final judgment rule exists in the first place, to avoid piecemeal appeals and to not disrupt the district court's management of the case. And they note that this does still leave the district court judge the role of kind of a gatekeeping function where they can allow appeals in appropriate circumstances because, as I mentioned, the district judge does have the authority to enter a final judgment on fewer than all claims of all parties when that court expressly determines that there's no reason for delay and that an immediate appeal is appropriate. So this would still allow, when appropriate, individual parts of an action, or one of several consolidated cases to be appealed before everything is finished. But again, it would leave that decision with the district court, which the district judge, who is presumably much more well acquainted with the case and can make those kind of judgments about when that would serve efficiency and when it would be appropriate for those things to happen. So they made this very pragmatic argument, and just as a policy matter, it seems very sensible. There's a lot of sense to that, just for the same reasons that the final judgment rule exists in the first place. There's a lot of sense to allowing consolidated cases to be treated the same way. But despite that argument, the court really doesn't even address that and just sticks with the text and the language of the rule and the meaning of the term consolidated as it gleans it from these past cases and other legal sources. So it's just an interesting note about how the court goes about deciding these cases and which kind of factors are really important to the court in coming to its decisions. So that brings us to the end of this live stream episode. The next live stream will be a week from today, and that's Thursday, April 5th. Again, at 9 p.m. Eastern time. That's our usual weekly live stream time, Thursdays at 9 p.m. Eastern. But you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Next week, it's expected to be a pretty quiet week. Earlier today, that's Thursday, March 29th, the court had its weekly conference that's usually held on Fridays of weeks where they have oral argument, but presumably because of Good Friday holiday tomorrow, they've held their conference a day early on Thursday. And there'll be an orders list Monday morning at 9:30 for orders coming out of today's conference. So that could include some new cert grants or potentially other interesting orders. And then there's also a possibility that the court could issue some more opinions on Monday. We don't know yet. Typically, the court announces Friday afternoon if it's expecting to issue opinions the following Monday. I haven't actually. It's possible they announced that earlier this week, given the holiday tomorrow, but I haven't checked that before this broadcast. So I don't know if there's going to be any opinions or if any are expected on Monday, but there could be opinions again as we get closer to the end of the year. And there's always a possibility of other emergency orders or interesting developments, but we'll see. But right now it's looking like likely a quieter week. But again, the cert grants or opinions could change that. We'll see. Whether you're watching this on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to me at mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or to the audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.